If you don't plan, you're stupid.
Hey there, welcome back to If You Don't Plan, You're Stupid with estate planning attorney Andrew Rosenberg. Andy helps Florida families protect their assets, avoid legal chaos, and make sure their wishes are honored. My name is Kevin Rosenquist, and today we're tackling a tough but important question. What actually happens if someone dies without a will in Florida? Andy, welcome back.
Hey, Kevin, how are you? Happy Friday, my friend.
Happy Friday to you as well. I'm sure this is a question you have gotten many times. Let's do a deep dive of it and get a little more info out there. But what does it legally mean to die intestate in Florida?
Okay. Yeah. So I cover this all the time in my workshops. And this is actually this is actually the first topic in my workshop. So basically, the legal term is called intestate. Intestate means, and basically all it means is dying without a will. That means you have no estate plan whatsoever in place, which is the worst thing you could possibly imagine doing.
Mm-hmm.
But I hate to tell you that the majority of people are like that.
Mm-hmm. And how does the state decide what happens to your assets if there's no will?
Well, I mean, that's the whole point of having a will, by the way, is at a minimum, the will's going to kind of let us know what you want done when you pass away, as far as your wishes, as far as burial versus cremation. If you want your assets to go to your kids, do you want them to go in equal percentages? Do you want one kid to get more than the other? All that stuff is done in a will. And by the way, if you die with a will, it's called testate. And if we die, like we're talking today, without a will, without any plan, that's intestate. That's the difference between the two. And what happens with the state, at least in the state of Florida, I'm sure all the states are similar, but they have different variances. But what happens is when you die without a will and you have assets in your name alone when you die, we're going to have to go through this court system called probate, which we can touch on in a couple minutes, Kevin. Mm-hmm. But the state of Florida, in a nutshell, has a statute called the Florida Intestate Statute, and that is going to determine how the assets go when you pass away if you were stupid enough to not have an estate plan. Hence, if you don't plan, you're stupid.
That's right. It's in our title.
Absolutely.
So walk me through a scenario. Let's say somebody dies without a will. They've got a spouse. They've got a couple of kids. So what does the process look like?
So the process is as follows. Usually what happens is when someone passes away, they contact an attorney. And they're going to contact someone like me who does probate administration, estate planning, that kind of thing. So then they schedule a meeting and we end up having them come into the meeting. And then it looks like usually the family comes in and they all look like, unfortunately, like a deer in headlights. They all just lost a loved one. Mm-hmm. And they're like, what in the world do we do? And so it's my job as the attorney to kind of guide them through the whole process. So the first question I'm going to ask is when I'm meeting with somebody, hey, did the person have a will or not have a will? And if they had a will, then I need the original will. If they don't have a will, then we're going to deal with what we're talking about, which is the intestate statutes. So then I have to sit down with them and the family members, the spouse. It's probably a spouse, or it might be a sibling or an old adult child. It depends on the situation. But we have to sit down and I have to gather information. I need to find out what in the world we're dealing with. Mm-hmm. And that's usually where the messy part comes in, Kevin, because what happens is I need to ask a bunch of questions in order for me to prepare what we call opening documents to get signed so that we can file with the courts. The initial beginning of the probate process, which is the probate process is when someone dies, it's the court process of getting assets transferred from the person that passed away to wherever we need it to go to. So all these questions I got to ask, a lot of times the family has no clue what the answers are. Mm-hmm. And I'll give you an example. first thing we're going to ask is, did this person that passed away, did they have any assets in their name alone? And that's usually a stumper right there.
Yeah.
And they're like, I don't know what that person had.
Yeah.
I don't know what my spouse had. I only know what we have together. I don't know exactly all the assets. I don't know where everything's located. I think he had bank accounts at Bank of America. I'm not quite sure. He did have a business. I don't know if it's an S corporation or an LLC. I think he had partners. And then all of a sudden, the Pandora's box opens. And here I am as an independent third party just being pulled into this equation and thinking, oh my God, this is going to be a nightmare. And hence, that's the process of probate court. So that's why it's usually a disaster, because most people don't know what in the world we're even dealing with. So what you need to realize is that when we're dealing without a will, and we have to go through the court process, that probate court process, the real reason we're going through that is to get these assets out of the person's name who passed away to the next generation or wherever it needs to go. But if there are no assets, then the question becomes, why do we even need to do a probate process? And a lot of times we don't. So there's a lot of issues that happen, but the beginning is obviously at the beginning. You got to get a death certificate from usually the funeral home. They're going to order them for you. It usually takes 5 to 10, maybe 15 business days to actually get a bunch of them. You should, and you'll get two types. They'll ask you at the funeral home, do you want the long form or the short form? The long form will actually give you the cause of death on it, and the short form will not. You need to get a bunch of each. Usually we want, as the attorney, the short form. We don't want to know cause of death. But usually you need to get about 10 to 15 death certificates to be on the safe side. And then we need those death certificates, the original death certificates, to file with the court, along with all these documents that we have to create for you. So that's just the beginning process of starting this dying without a will process, Kevin.
That's just the beginning.
Did that confuse you, or did it make sense?
I mean, it makes sense, but I can see it's a lot, just what you said there. I mean, we haven't even gotten to court yet, and you're already telling about all this stuff. So it definitely sounds like a lot to deal with, especially as you pointed out, while people are still grieving.
Yeah. And that's the worst part. And that's what I tell everybody in the workshops. I'm like, listen, the last thing in the world that you should want to do to your family is have them stress out about, if you pass away, where my assets are, where my liabilities are, where my username, digital assets, my usernames and passwords. Where is all this stuff? Because they should only need to worry about you and about laying you down to rest in the way that you want it done. And if you don't have anything planned and you don't have all this stuff organized, your assets, your liabilities, all your usernames, passwords, you name it, it just is really hard on the family. And imagine, by the way, Kevin, we haven't even talked about it, which I know we're going to talk about, but imagine if there's a blended family situation. You got kids from a first marriage, you got kids from the current marriage, and then the wife had kids from a prior relationship. All of a sudden, you got all these different people that are going to get involved, and that's not going to be fun.
No doubt.
It makes it that much worse.
Is there any difference as far as how Florida law decides who inherits what? If, let's say, in that same scenario, couple has kids, but they weren't technically married?
Yes. Yeah. So listen, in a will situation, you can pretty much give your assets to whoever you want to.
Sure.
You can disinherit people. You can give everything away, not give it to the kids. You name it. You have that right. The one thing that you can't do, and the people listening out there, you need to know this: you can't disinherit your spouse, even if you wanted to. You cannot. Okay. That's why we have pre and post-marital agreements, so that you can, if that's what you want to do. Otherwise, we have something in Florida called an elective share, which is a whole separate podcast. We can talk about what the rights are for the surviving spouse. But the answer to your question is, if you are married, let's take two scenarios, Kevin. Let's say that you're married and you have a couple kids, 2 kids. And let's take it a step further. This is how complex it can get with dying intestate. So I'm married to my wife, and we have 2 kids. The 2 kids are from the marriage together, my wife and I. Okay.
Mm-hmm.
And I pass away, and I have assets in my name alone. Okay. That's the only time I have to go through probate, by the way. If I have assets that are in joint name with my wife, so my wife's name is Debbie. If Andy and Debbie own an investment account as Andy and Debbie Rosenberg, joint tenants with rights of survivorship, or Andy and Debbie Rosenberg as husband and wife, one of us dies, it automatically goes to the survivor. So there's not going to be a probate issue. But now the survivor dies, now we have that issue. So
Right.
it gets pretty complicated. But let's just assume that I had assets in my name alone. I have bank accounts, etc. I had no will, no anything in place. So that's dying intestate. And I die. And I have a wife and 2 kids. And the 2 kids are from our marriage together. In that situation, we look at the Florida intestate laws and the statutes. And my wife would get 100% of everything in that situation. However, let's change it let's tweak it just a bit, Kevin.
Okay.
Let's say that I die and I'm married to my wife, and I have 2 kids, but they're not from her, from a prior relationship, and we don't have any kids together. What happens there? The wife will get 50%, and my 2 kids are going to split the other 50%.
Okay.
So and then imagine if you passed away and you're not married, right? And you have no kids. Then what happens? There's a whole statute that we go through to determine this. This is how crazy it can get.
Yeah.
I mean, in that situation, it usually, I believe, it goes to your parents if you have surviving parents and you got no spouse and no kids. And then if you don't have parents, then we go to your brothers and sisters. And then if they aren't alive, how about their kids? So it kind of goes through a whole pecking order situation. But you asked the interesting, it's kind of nuts. You asked a really interesting question, and I don't think you even realize it. What happens if I'm not married and I have a partner that I have? The partner gets 0. The partner gets nothing.
No matter how long you've been together.
You could be together for 1 month. You could be together for 20 years. You are getting 0 as the surviving partner in that situation without any estate plan in place.
Mm-hmm.
Completely different if we decided to do a will and we wanted to leave everything to my partner. That's allowed. But without that in place, Florida does not recognize partners. You are done. And you literally could get kicked out the next day by the family members, and that it's a disaster. I mean, and I see it all the time, unfortunately, and it's just I get frustrated when I see this because I promise you, the person that passed away, they didn't think like this would ever happen.
Sure, it's not what they wanted.
Yeah, it's not what people wanted. And again, we go back to prior podcasts, Kevin. I tell people all the time, why do people not do this? Why don't they do a basic will or a trust or whatever? And the answer is, in my opinion, number 1, they're procrastinating. Number 2, they think they'll take care of it tomorrow. I'll take care of it tomorrow. And guess what? A lot of us, tomorrow doesn't happen. And that's the problem. We don't plan on dying most of the time. It happens. I don't think Robert Redford just passed away. I mean, he was older. He was 89.
I saw that. Yeah.
But I believe he was fine. He was doing great. He went to bed and just never woke up.
Yeah. Yeah. It's a good point. I mean, we don't choose when we die most of the time. So, So let's get back to this. I have some other stuff I'd like to know. One of the things is the personal representative. So, someone needs to take care of everything, right? So how does the court choose a personal representative if the deceased never named one?
Right. Well, hence another reason to have a will, right, Kevin? Okay. So there is
I see a pattern here.
Yeah. So there is method to the madness with the courts. Just like we have a Florida intestate statute as to where the assets will eventually go when you pass away without a will, the courts also have a preference as to who to name as the executor. A lot of people are familiar with the term executor. In Florida, we call it a personal representative or PR. It's the same thing. That's just what we call it. If you have a spouse, the preference is obviously going to, and there's no will in place, the preference is going to go to the spouse. That is always priority number one. However, if the spouse has a felony conviction of some sort in their background, the courts will not appoint that person, more likely than not. Very hard for the courts to say, we're going to allow you to be in charge of an estate if you have a felony conviction. Or what happens if the spouse has mental incapacity issues and they're not able to deal with things. So then the next question is, who would be the next in the pecking order after the spouse? And what happens in that situation is the courts usually like to go to the heirs and say, give me someone you want to appoint. Meaning, of the 4 or 5 people, any one of you want to be, majority of you want to vote and say, yeah, let's have this person involved. And
okay, so they do kind of they don't just force it on them. They do kind of give you some choices.
They give you some choices. I'll give you a quick example. I did a probate recently, and the person passed away, and the mom was supposed to be the personal representative. It was the son that passed away, not married. So the mom would have been a personal representative. Unfortunately, we tried, and the mom had a felony conviction. So then the court said, who do you want to name? And I said, as the attorney, I said, I'll be the personal representative as the attorney if you prefer to have me do that, Your Honor. And the court appointed me as personal representative. So a lot of times, the attorney may end up being a personal representative, not out of choice, but out of necessity.
Mm-hmm. Mm-hmm. Since we're talking about all this intestate stuff and you keep saying the same thing, gotta have a plan. For all those people that procrastinate or just say, oh, well, keep kicking that can down the road, what's a good way to get started? What's a way for them to just say, okay, I'm going to do this. I'm going to do this now. What do they need? What should they have? What should they get going?
Okay. Well, number one, you need to realize in Florida, you cannot do a holographic will. That's basically your own will written down on a sheet of paper or whatever that, and it doesn't have the proper formalities. That's not going to work. Okay. So what's that mean? That means that you probably should meet with someone like me, an attorney. So my suggestion is as follows. There's number one, talk with your family, talk with your spouse, talk with your kids, and let them know what your wishes are, just so they know. Then, and talk to people. I always say communication is always the most important thing. Yep. Let everyone know what you want to do, because what you want to do is important, okay? And now that you have an idea and you've spoken to your family, put it down on paper. Meet with a proper licensed estate planning attorney and let them hear what your wishes are, and then put it down in the proper formalities in Florida to make it a will. And then by doing that, then at least we have, at least that's taken place. Otherwise, if the worst thing you can do is this whole podcast is die without any estate plan in place and leave everybody in limbo and cause a complete disaster.
And an important point, which is we've made and we'll make again, is you're not doing this for yourself. You're doing this so people that you're leaving stuff to or your heirs, they don't have to go through this process that you've just been thinking about. So think of your kids, think of your spouse, think of anybody who might have to go through this and just get it done, right?
Yeah, exactly. Yeah, don't be selfish, okay? Don't think about yourself. Think about everyone that survives you and realize that they're going to be mourning your loss. And how can you minimize that whole process? Yeah, hopefully. You never know. There may be some people that may not be mourning my loss if that happens. but hopefully, let them mourn properly, right, and not let them have to stress out about this whole process that we're talking about. They're going to have to deal with it no matter how you look at it. Yeah. But it's much easier to deal with if we have a plan of action written in place versus not having anything in place. So just think about that when you do this. And I know we're running short, but I always tell my kids, and my kids tell me this, when we do things like this, like we're doing a will, we're doing an estate plan, we're doing whatever it is, my kids will look at me and say, Dad, we're adulting. I said, and I think that's a great way to end it. You know what? Be an adult and start adulting. Take responsibility and make sure that you plan for your future and when you're not around to deal with it.
I love that. I love that. People, start adulting. All right. Well, thanks for joining us today on If You Don't Plan, You're Stupid. If you want to make sure your family isn't left guessing or fighting, for that matter, after you're gone, visit rosenberglawfirm.net to start your plan today. And as always, don't forget to leave us a review, subscribe. We very much appreciate it. Always love the advice, Andy. Love chatting with you. Thanks so much for being here.
You too. Thanks, Kevin. I'll talk to you soon.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.